Thank you, Sal, and thank you to Michael and Stephen for their discussion about subject matter eligibility or patentability in the computer software arena. Now I'm going to move into biotechnology and the life sciences. Some of the same principles outlined in Michael and Stephen's presentations also apply in these areas, but the application of the general principles can be quite different. First, I'm going to provide a brief background of Supreme Court precedent in the area of subject matter eligibility of biotechnology and life science patents. While these come from, starting in 2012, it's a good reminder, and these cases are often used throughout the Patent Office's examples and rejections you'll receive. Briefly, in the Mayo case, the Supreme Court established a framework for distinguishing patents that claim laws of nature, natural phenomena, and abstract ideas from those that claim patent-eligible applications of those concepts. At issue in Mayo were methods for calibrating the proper dosage of thiopurine drugs. When ingested, the body metabolizes the thiopurine drugs, producing metabolites in the bloodstream. Each of the claims at issue recited an administering step instructing the doctor to administer the drug to the patient, a determining step which tells the doctor to measure the resulting metabolite levels in the patient's blood, and a where-in step, a step which describes the metabolite concentrations above which there is a likelihood of harmful side effects and below which it is likely that the drug dosage is ineffective. The two-step test set forth by the Supreme Court requires you first to determine whether the claims are directed to an unpatentable phenomena of nature, mental processes, or abstract intellectual concepts. In this case, the Supreme Court determined that the patent claims at issue set forth laws of nature, namely the relationship between concentrations of certain metabolites in the blood and the likelihood that a dosage of the thiopurine drug would prove ineffective or cause harm. That relationship is an unpatentable law of nature because the relationship is a consequence of the ways the drugs are metabolized by the body. If you could go to the next slide, Sal. The court then stated what did not suffice to transform an unpatentable law of nature into a patentable application of that law, which is where a lot, I think, of the confusion stems from, because the court's always telling you what's not eligible rather than what is. And the court stated that, in essence, adding routine known elements to the claims is insufficient. The steps common to the claims at issue in Mayo were the administering, determining, and where-in steps that I noted above. The administering step had been performed by doctors long before the asserted claims. The determining step simply told the doctor to determine the level of the relevant metabolites in the blood, and methods for determining those levels were well known in the art. Finally, the where-in clauses simply informed the doctor about the relevant natural laws, and at most added a suggestion that the doctor should take those laws into account when treating the patient, i.e. the doctor should adjust the dosage. And the three steps as an ordered combination added nothing to the laws of nature that was not already present when the steps were considered separately. Therefore, the steps did not add an inventive concept, and you'll hear that as the presentation continues, sufficient to transform unpatentable natural correlations into patentable applications. If you could go to the next slide, Sal. Another case in the biotechnology area is the Myriad case decided in 2013. The Myriad case involves not methods, but analyzing products of nature. There, the Supreme Court held that a naturally occurring DNA segment is a non-patentable product of nature because the nucleotides isolated by Myriad existed in nature before Myriad found them. On the other hand, the creation of a cDNA sequence from mRNA results in an exons-only molecule that is not naturally occurring. Therefore, cDNA was patentable subject matter. And in this case, the Supreme Court set forth the general rule that in order to patent a natural product, that product has to have markedly different characteristics than the product found in nature. In other words, it has to have a distinctive chemical identity from molecules that exist in nature. Next slide, Sal. After the decisions in Mayo and Myriad, the Federal Circuit decided a number of subject matter eligibility cases regarding life science and biotechnology patents. Many of these decisions found that the claims were directed to an abstract idea or a natural phenomenon, and that the claims did not demonstrate a sufficient inventive concept to make them patent eligible. In Perk and Elmer, a 2012 non-precedential decision, the claims were directed to a method of determining whether a pregnant woman is at an increased risk of having a fetus with Down syndrome. The patent claimed analytical methods to determine the risk of fetal Down syndrome, including measuring steps and a determining step in which the risk of Down syndrome is calculated by comparing screening marker measurements with known statistical information. The court therefore found that the claims recited the mental process of comparing data to determine a risk level, and that the claims also recited a law of nature, the relationship between the screening marker levels and the risk of fetal Down syndrome. The other steps of the claim method did not disclose a sufficient inventive concept to render the claims patent eligible. In the SmartGene case, which was mentioned by Steve in his presentation, a non-precedential decision, it involved a method, system, and computer program for guiding the selection of a treatment regimen for a patient with a known disease or medical condition. This claim was directed to an abstract idea. It did no more than call on a computing device with basic functionality to compare stored and input information and rules to do what doctors do routinely, select a treatment regimen. In the hereditary cancer test patent litigation case, also known as the Ambry case, the claims were directed to single-stranded DNA primers for a determination of a nucleotide sequence of a BRCA1 gene and a method for screening for mutations. The claimed primers were indistinguishable from the isolated DNA found patent ineligible in Myriad because they were structurally identical to the ends of DNA strands found in nature, even though the primers were synthetically replicated. As I noted before, naturally occurring compositions of matter and synthetically created compositions that are structurally identical to the naturally occurring compositions are not patent eligible. The method claims in Myriad, or in the Ambry case, were also ineligible subject matter because they claimed an abstract mental process of analyzing and comparing two gene sequences. The other elements of the claims didn't add enough to make the claims as a whole patent eligible. The steps set forth routine and conventional activity engaged in by scientists at the time of the patent application. For example, the comparison step did nothing more than spell out what practitioners already knew, how to compare gene sequences using routine, ordinary techniques. If I could have the next slide, Val. Two decisions on this page were widely discussed in the biotechnology and life sciences arena, and many practitioners were hoping that certiorari would be granted so that the Supreme Court could clarify the scope of patent eligibility or perhaps broaden patent eligibility in the life sciences and biotechnology area. Unfortunately, the Supreme Court did not take either of these cases. In the Ariosa case, the inventors discovered that cell-free fetal DNA, CFF DNA, existed in a portion of maternal blood samples that other researchers had previously discarded as medical waste. Applying a combination of known laboratory techniques to their discovery, the inventors implemented a method for detecting the small fraction of paternally inherited CFF DNA in maternal plasma or serum to determine fetal characteristics such as gender. Notably, the patent didn't claim CFF DNA or paternally inherited CFF DNA, it only claimed certain methods of its use. The steps of the method claim included amplifying the CFF DNA contained in the sample of plasma and detecting the paternally inherited CFF DNA. The patent also provided methods for making a diagnosis of certain fetal characteristics based on the detection of paternally inherited CFF DNA, including a more efficient determination of genetic defects. The Federal Circuit held that it was undisputed that the existence of CFF DNA in maternal blood is a natural phenomenon. It was also undisputed that the method ends with paternally inherited CFS DNA, which is also a natural phenomenon. Therefore, because the claims at issue were directed to naturally occurring phenomena, the court went on to the next step and examined the elements of the claims to determine whether they contained an inventive concept sufficient to transform the claimed naturally occurring phenomena into a patent-eligible application. Unfortunately, the court determined that the claimed method amounted to general instructions to doctors to apply routine conventional techniques when seeking to detect CFS DNA. The preparation and amplification of DNA sequences in plasma or serum were routine conventional activities. Likewise, the detecting step was well understood, routine, and conventional because those skilled in the art had a broad range of techniques available for the detection of DNA in a sample. In the genetic technologies case decided in 2016, the Federal Circuit determined that the claims were directed to a law of nature, the relationship between coding and non-coding sequences, and that the claims did not have a sufficient inventive concept to render them patentable. Genes typically contain both coding regions, called exons, and non-coding regions called introns. The inventor discovered that certain DNA sequences in coding regions of certain genes were correlated with non-coding regions within the same gene. The inventor concluded that the alleles of a particular gene may be detected using well-established laboratory techniques, not by looking for the coding region of the gene, but instead by amplifying and analyzing the non-coding regions known to be linked to the coding regions. The claim at issue was a method for detecting a coding region by amplifying and analyzing linked non-coding region sequences. The method claim, therefore, relied on a natural principle, which is the tendency of the non-coding and coding regions to be linked. The court determined that the additional elements of the claim were insufficient to provide the inventive concept necessary to render the claim patent eligible. The claimed steps of amplifying genomic DNA with a primer pair and analyzing the amplified DNA were both routine and conventional at the time the patent was filed. The novel part of the patent was the discovery regarding CFS DNA, which was a natural law. If you could go to the next slide, Sal. Just for your information, there's a few district court decisions that are currently on appeal whose resolution might perhaps provide further clarification of the issues. The Cleveland Clinic case, where the appeal was filed in March and is going to be argued this April, and that was March 2016, involved a method of analyzing the risk for cardiovascular disease by analyzing biomarkers in a patient's blood sample and comparing them to markers in the control subjects. The court found that the patents at issue were directed to a law of nature, and that is the correlation between the biomarker in the blood and the risk of cardiovascular disease. The determining and comparing steps did not provide an inventive concept sufficient to render the claims to the natural law patentable. In the Vanda Pharmaceuticals case, the method at issue was for treating a patient suffering from schizophrenia with iloperidone through the use of a genotyping assay and adjusting the dosage based on those results. The court held that the asserted claims depended on laws of nature, which is the relationship among iloperidone, how it is metabolized, and a phenomenon called QTC prolongation, which can alter both the performance and side effect profile of the administered drug. So the court went on to step 2B, in essence, and analyzed whether the claims incorporated some additional steps sufficient to transform the claims and making them patent eligible. The claims, the court found, added to the law of nature, including conducting certain genotyping tests to determine the appropriate dose of iloperidone to reduce QTC-related risks. The court found that while it may have been conventional to investigate for side effects, the defendant had not proven by clear and convincing evidence that the precise test and the discovered results were routine or conventional. The dosage step in the patent did not apply to all patients, but only a specific patient population identified by genetic composition. Further, the process of using the genetic test to inform the dosage adjustment resided in the claims was not routine and conventional and amounted to more than a mere instruction to apply a natural relationship. If you could go on to the next slide, Sal. Now, this is the streamlined analysis, which is going to relate to the examples I discussed later. This is the rapid litigation management case decided in July 2016. And the streamlined analysis is where the court finds that the claims are not directed to a natural law or phenomenon, and therefore it doesn't need to go on to step 2B to determine whether the method steps provide a sufficient inventive concept to render the claims patent eligible. As background, hepatocytes are a type of liver cell that has a number of attributes useful for diagnostic purposes. For example, they can be used to investigate how drugs under development may be metabolized by the liver. Their use had been limited because they could only be obtained from liver resections or non-transplantable livers of organ donors, and their lifespan is short. The erratic supply made availability limited and unpredictable. Prior to the invention, scientists developed cryopreservation techniques to preserve the cells for later use, which included freezing them, then thawing them, and recovering the viable cells using density gradient fractionation. The prior art cryopreservation methods had problems because they could damage the cells and were unsuitable for preparing multi-donor pools. Hepatocyte pools allowed researchers to approximate average liver cells to study a drug's impact on a representative population. The inventors discovered that some fraction of hepatocytes is capable of surviving multiple freeze-thaw cycles and developed an improved process of preserving them. As outlined on the slide here, the improved process comprised the steps of subjecting previously frozen and thawed cells to density gradient fractionation to separate the viable cells from non-viable ones, recovering the viable cells, and refreezing the viable cells. The patented process had a number of advantages over the prior art, including facilitating the production of pooled preparations, which was not possible with the prior art cryopreservation techniques. The Federal Circuit here held that the claims were not directed to the natural law. They were instead directed to a new and useful laboratory technique for preserving hepatocytes. The claims did not result in simply an observation or detection of the ability of the cells to survive multiple freeze-thaw cycles. The claims were like thousands of others that recited processes to achieve a desired outcome. For example, methods of producing things or methods of treating disease. The Federal Circuit noted that the fact that a claim depended on a law of nature did not make that claim directed to a law of nature. For example, a method of producing a new compound is not directed to a law of nature simply because it relies on the individual component's ability to form the new compound. If you could go to the next slide. Even though some of the cases we have discussed found life science patents innovations patent-eligible subject matter, drafting patent-eligible claims in the life sciences or biotechnology areas can be a daunting proposition. For example, data presented at the Intellectual Property Scholars Conference in Stanford addressed patent applications in 8 categories that commonly include personalized medicine patents. The data demonstrated that following the Mayo decision in 2012, the Patent Office was nearly 4 times more likely to deem the subjects of such applications unpatentable, and applicants were less than half as likely to overcome Section 101 rejections. And some of that data is referenced on this slide and is sourced from the Chow and Mapes article up on the left-hand side there. Based on the data set analyzed, the results showed that Section 101 rejections rose dramatically after Mayo from approximately 16% pre-Mayo to 86% of the office actions post-Mayo having rejections under Section 101. Another author, Robert Sachs, which is the chart at the bottom, tabulated the rates of Section 101 rejections for various Patent Office technology centers. 1600, which is biotech and chemistry, which is a larger set than the Chow data, indicates that around 10% of biotech and chemical inventions incur 101 rejections. And that includes many inventions which would never have any problems. So in trying to break it out, for example, chemical engineering only had a 2.5% rate of rejection, whereas immunology and microbiology went up to a 12% rate, and molecular biology had nearly an 18% rate of rejection. So the question you should think about is whether filing a patent is always the best option. A lot of biotech companies have not focused on trade secrets, although some of them use trade secret protection, particularly for manufacturing processes. And there are other uses of trade secrets. For example, Myriad has focused more on its huge proprietary database of genetic mutations and associated health outcomes, which it built over many years when it had a patent monopoly in the BRCA testing field. But a trade secret may not be practical in all situations. For example, for diagnostics, you generally need to publish most of the details of the test in a peer-reviewed journal to get reimbursement. If you could go on to the next slide. If you decide to go forward with the Patent Office has issued numerous guidance documents. Steve already discussed a lot of these, but here's a list of the guidance documents particularly relevant to biotechnology, which are available on the PTO website. Relevant to biotechnology, the July 2015 update provided a further explanation of the markedly different characteristics analysis. In May 2006, the Patent Office issued Life Sciences Examples 28 through 33, and the July 14, 2016 memo outlined recent subject matter eligibility rulings for the Patent Examining Corps, including rapid litigation management and Sequinome versus Ariosa. If you could go on to the next slide. Steve discussed the Patent Office's flow chart for the two-step patent eligibility test. As he noted, in flow chart step 2A, which is the first step of the Mayo analysis, it is determined whether a claim is directed to a law of nature, a natural phenomenon, or an abstract idea. If step 2A is no, the invention is eligible for patenting and no further analysis is required. And that is, in essence, the streamlined eligibility analysis. A lot of times examiners do not detail specific reasons for using this analysis, but they're encouraged by the guidelines to make a short comment on the issue. And as I noted, I'll be going over examples of that analysis later in this presentation. Further, although it's not shown clearly on the flow chart, the July 2015 update retained the markedly different composition analysis for natural products at step 2A. So there's two pathways to eligibility for many claims directed to product of nature exceptions. If it is determined that the nature-based product has markedly different characteristics from what occurs in nature, the claim qualifies as eligible subject matter without any further analysis. Examples of this include the cDNA analysis in Myriad. Products of nature that do not have markedly different characteristics from the nature-based product may have subject matter eligibility if the claim as a whole amounts to significantly more than the natural product. And as noted by Steve, if the court is, or if the examiner is going to determine that the claim is directed to a law of nature or natural phenomenon, the rejection needs to identify that law and explain, using a reasoned rationale, why that principle is considered a law of nature or natural phenomenon. The examiners are supposed to compare the claims to the ones addressed in the case law, and as Steve noted, this might be an area of attack in response to an office action if no explanation is found or if the facts of the case don't really match the claims. If you could go on to the next slide. If the claim is directed to a law of nature or natural phenomenon, you go to step B, which my colleagues in the second half of the presentation will address. And at that step, it needs to be determined whether the claim recites additional elements that amount to significantly more than the judicial exception. Okay, and if you could go to slide 64. And these are two examples of the streamlined eligibility analysis where step 2A is done and the analysis stops. And it's kind of telling that it's based on two relatively old Supreme Court cases. And example 32 is, in essence, a paper-making machine that is fed by gravity, and it was based on a U.S. patent upheld by the Supreme Court in IBLE process, a 1923 Supreme Court case at 261 U.S. 45. And in essence, prior art machines had difficulty. They had to run at an overall slow speed in order to avoid undesirable effects on the paper web. An applicant's invention solved the problem of running the process at a slow speed by raising the paper-making wire on one end to a height substantially above the other end and using gravity to feed the stock into the machine at a faster speed. The actual claim is on the slide here, and it's not directed to a judicial exception. Although it operates using gravity, which is a law of nature, it doesn't seek to tie up this law of nature, and it's clear that the claim as a whole amounts to significantly more than the mere use of gravity because it provides meaningful limitations of the law of nature. And the next example of the streamlined analysis is based on technology upheld by the Supreme Court in Tilligman, 102 U.S. 707. And basically, it was already routine to break down fat molecules into free fatty acids, but the prior art processes used a steam distillation step and required mixing with lye or sulfuric acid. And the applicant here invented a process of hydrolyzing the fat molecules into free fatty acids and glycerol without steam distillation and using only water. Again, the steps are outlined on the slide. And although the claim was founded upon a chemical principle relating to neutral fats, it wasn't attempting to tie up any judicial exception, and the steps of the claim made it clear that the claim as a whole would amount to significantly more than any potential recited exception because it affects the transformation of the fat and water into different chemicals. So you don't need to perform the full eligibility analysis, even though the claim is clearly based on a law of nature, a chemical principle that the elements of a neutral fat require that they be united with an atomic equivalent of water in order to separate from each other and become free. So the takeaway from these examples is that in drafting the patent claims, you should avoid any step that states the law of nature and instead concentrate on physical steps and, if applicable, an apparatus used in the claim, and concentrate on a process that has a concrete result. If you could go to slide 66. And this is my final point here. This is an example of a streamlined analysis from a recent PTAB case. It's a method of detecting a plurality of different target nucleic acids in a sample. And here the PTAB reversed the examiner's decision that the claim should be rejected under 101. And if you could go to the next slide. The main point here is that the board was not persuaded that the detecting step recited in the claim process was an abstract idea because step F of the applicant's claim required an actual physical detection of amplified nucleic acids. It wasn't a mental step, such as reading a report or viewing a result. The PTAB also found that the examiner had not explained adequately why the concrete physical steps were analogous to the abstract mental processes involved in the critical comparison step in the Ambry case. The PTAB also found that the examiner did not properly evaluate the claimed invention as a whole in determining that the claim process recites nothing more than the use of conventional steps to implement the alleged abstract idea. So basically, ways to, as Steve discussed, challenge the examiner's reasoning sometimes can result in an allowed claim.